2 documents.
Sorry.
10 statements and 2 documents.
You served that one?
Those one was served earlier. And today, we served 21 witness statements and a list of 13 documents.
We did that correct as before today 10 had been
Yes,
served.
earlier on, there were
And then 20,
plus
how many?
21 statements of witnesses.
This 21 additional to the 10?
Yes. And 13
21 statements, sorry.
13 documents.
And?
13 documents. That makes a total of 31 prosecution witnesses, witness statements, and 15 documents.
Did I say 13 or 15?
15 now. I'm adding. The tally now. Joanna, as regard, let me say this. An attempt was made to serve another senior counsel, but he declined. And
This today?
indicated that he would rather wait for the ruling, but we will still carry the statements with us.
That is a statement or what?
The bundles, the 21 witness statements and the 13 documents.
Yes.
So they were declined, but we carried them because we were advised to wait for the ruling before court.
Were they declined by what?
That is a counsel for the first accused. But the counsel for the second accused accepted the disclosure and is stamped receipt. I want to share the court. In that respect. Yana, let me address the second issue. That issue. Let me now have stated the status as of now. As of what is outstanding, the honor you receive from record is a letter dated 22nd of January 2020 from the government chemist. 26 samples were
A letter dated when?
22nd January 2020, which is in the court file. And what the government chemist advised the DCA was that from that date they required 2 months to do the analysis of the 26 samples that had been delivered to the government chemist and render a report. Your Honor, my calculation takes the date of 12 to 25th March. That matter is outstanding. However, separately, we have 2 statements of witnesses who are under witness protection and had advised the IO to have some of the particulars tending to identify the witnesses being redacted before we serve. That is 2 witnesses.
They were not in the bundle.
Sorry?
They are not in the bundle.
The other is bundle. We will serve the board they are redacted as required by the law. I'm also informed, Your Honor, that there are also 2 more witnesses being interviewed by the WPA, Witness Protection, on their to assess. They are normally interviewed before they are assessed, and once that process to take long is done, we will disclose their statements together with the first two. Because we have them, then include them. That is 4 now.
That makes 4.
That makes 4 now. That is witnesses and the witness protection. The witness protection and the process, being processed. Secondly, we have 4 witness statements we are expecting. And these are the statement of the officer in the cyber crime lab who is analyzing the form data. Statement of IO. Statement of an expert who is forensically examining the maggots that were found on the body of the deceased. Yes, some samples are taken to an expert. These are maggots recovered from the body of the deceased for forensic examination, and we expect a report and a statement. And statements from service providers, Salanco, and probably that.
You say statements, maybe you could be clear and say.
We are talking about statement of witnesses and reports from service providers. Are meant to be given exactly who are these service providers so that they can disclose to the court.
And the number.
Yes, and yes. So basically, my lady, we expect to bring about 8 to 10 statements. Which will answer now to the completeness of the investigations by the DCI. Yes, finally, I want to be allowed to make a proposal which will be acceptable to both sides, so that we can address these issues without delay and ensure that there will be no adjournment when the hearing comes on beginning the 6th of July. Given what I've meant in the submissions, we are praying that will be given when the prosecution up to 30th of April this year. To ensure that we have disclosed everything touching on this matter. Then we'll be praying for a mentioned date in the mid of May, or within a week from 30th. Actually, it can be shorter, even if it's 7 days, even 4 days. The first week of May, we can come back to you to demonstrate compliance. Then we will pray. My lady had
I think you quite captured the focus
Yes.
of the nation.
We want to be given up to 30th of April.
No, the 30 they got. The nation after 30.
Within a week or less, we come before you to demonstrate we have complied. We've served everything, we've marked everything well, all the supplies are met, and we are beginning to prepare. Thereafter, we are dealing with you and the defense. We'll be allowed to come in the same month for our retire. And we need 2 weeks because month of May. Probably the last week of month of May, we will conduct our retire. Where now we will indicate in each statement of a witness the time the witness will take, the documents will be produced, and probably the time the prosecution case will take, the net time. Lastly, I wish to say this, that we are determined as members of the DPP, determined and focused as the office of the DPP to ensure that this not expedited. As you have seen, very little remains to be done by the DCI. And we don't want an adjournment and the hearing need to be based on the fact that there is more disclosure. In any case, my lady, we are saying that if you give us up to the month of April and the picture is done in the month of May, there will be a whole 1 month for the parties to prepare themselves. I also want to add that this matter has been complex, given its merits. New grounds keep coming, but they are being managed well. And further that, my lady, we are not intended to be involved in any circus whatsoever. We want to be focused. To expeditious disposal of this matter and require quiet environment, and I wish we can discharge our burden which is rests on our shoulders by the Lord. I think that's all. Give that promise.
Make my afternoon when you stand, I start shivering because I know the heat that is going to emanate from
For me, I got an instant headache
yes.
just listening to my colleague.
Yes.
I can't believe what I heard. Let me start with the first charge sheet filed in this case.
Before we go to the first charge sheet,
Yes. Yes.
There are certain things he has addressed as having some. Perhaps we could start by confirming or denying.
I rejected service at about 1:30, about 1:15 today. I understand somebody called Inspector Otieno came to my office to serve me with some statements, and I said to serve me 45 minutes before a ruling is to preempt what might be coming in the ruling. So I said serve in court depending on what the ruling on directions will be. It is very possible, Your Ladyship, maybe I was being too hopeful, that you might have made an order that what is not served stays with the prosecution and we proceed on what is served, given the time it has taken. So it was based on legal considerations. Now that you have ruled in the manner that you have ruled, your leadership, they are at liberty to serve us, which I look at what they have.
All right, proceed.
On 12th September 2019, one Nicholas K. Mutuku, OGW, Deputy Director of Public Prosecutions, signed a charge sheet for the offense of murder against the first accused. Very senior colleague of mine. When I say colleague, I mean as an advocate. I have also worked with him when I was a DPP. At the back of that charge sheet, Mr. Mutuku indicated copies of the evidence which the prosecution intends to adduce at the trial are attached here. Copies of documentary exhibits may be inspected by yourself if released on bail, or by your advocate on prior arrangements with the investigating officer, Mr. Maxwell Otieno, Mr. Inspector Clement Mwan. The leadership, Mr. Nicholas Mutuku lied on the 12th of September 2019 to this court. Why should I believe him today? He lied. Why should I believe him? Why should the court believe him today? Over 6 months after the first accused was charged, Mr. Mutuku now wants 2 more months, making a total of 10 months from the date of his first lie. That's now when he says he will be able to avail to us the evidence upon which he relies to prosecute the first accused. It is a great shame for the office of the DPP. But I go on to say, and I am glad today, and I'm glad for your directions, your leadership, that you have finally forced the DPP to indicate who the prosecutors in this case will be. Why? Because we have seen exactly what the court has seen. Again, of different prosecutors coming to court every day, which prevents accountability for any statement made. We don't know who we are up against. Each prosecutor says, it wasn't me. But today, my good friend Cohen has said, it shall be him. And Ms. Gishui. Again, just on that point, the last time we were here, Ms. Gishui gave us a list of 5, including the 2 of them. Why did she have to tell us something that was not true? What will the next prosecutor come and tell us? Mr. Mutuku was not serious. But it is fortunate that finally we know if we take them to their word in the light of their ruling. And I would like to take this early opportunity to say, and I have indicated it several times before, including in the application dated 2nd March 2020, filed on that day, and I think it's dated 27th February 2020, but it is filed on 2nd March. The leadership, at paragraph on page 6, grounds upon which we have based that particular application on.
You are arguing the application?
No, I'm not arguing it. I am touching on the prosecuting counsel. At the last paragraph, we have indicated, in addition, Ms. Catherine Mwaniki, SADPP, Mr. Nicholas Mutuku, DPP, the Deputy DPP, DDPP, and Ms. Gakui, prosecuting counsel, were present at the controversial recovery of the body of the deceased, which makes them witnesses and therefore incapable of prosecuting this case. So I'm giving notice here now that we will be objecting to Mr. Nicholas Mutuku and Ishui prosecuting the cases because they are witnesses. In fact, I want to look at my bundle quickly to see whether they have recorded their statements. The centerpiece of this case is where the body of the deceased was found. And the three prosecutors were there at the alleged recovery, giving directions to the police. They are material witnesses. Why do I say they are material witness? It is the defense case that the body was planted there. So whoever says it was found there must call all witnesses who were present during the alleged recovery. Your Ladyship, the last mention of this case, Ms. Kishui said she needs 2 weeks. 1 week ago, it would have been expected that Mr. Mutuku would say, we have provided so many other statements, we stick to our request for 2 weeks. In 1 week we shall provide everything. Your Ladyship, Mr. Mutuku has asked for another 2 months, until the 30th of April 2020. That will have given them 10 months. And thereafter he has the audacity, shameless audacity, to say, we can then have a pre-trial 1 month later, then we can be all ready for July. If the defense agree, we can cooperate. And if we further cooperate, the case will proceed without adjournments. Ladyship, they will have had 10 months and they will have given the defense less than 2 months, and they consider that fair play. It's actually less than 2 months, about 3 weeks to prepare. I call that ridiculous, I call that presumptuous, I call that arrogant, I call that a reflection of impunity. This case is about, of course, the deceased, but certainly about the rights of victims, the rights of the accused. But what we have been treated to here is a complete circus, complete trampling of the rights of the accused, in violation of Article 50, Sub-Article 2C. Your Ladyship, I have said this before. My learned friend now says, provided so many statements, totaling so many. Then he goes on to say, 2 more statements will come that are witnesses under witness protection. 2 more under consideration by way of witness protection. Cybercrime, investigating officers, maggots experts, and service providers. 8 to 10 more statements, Your Ladyship. It is already a mistrial. It's already a travesty of justice, and may go down already as the most scandalous investigation and prosecution in this country. The Constitution requires that the investigation should have been completed before the accused, 1 and 2, were charged. The law permits for the occasional dimension or bit of evidence to be admitted after that, because of course the prosecution cannot anticipate everything. But what we have seen here, Your Ladyship, is a case where it now is clear the two accused persons were charged on a whim, on a fancy by Mr. Mutuku and those who asked him to sign that charge sheet. And thereafter, what we have embarked on is a journey to find the evidence to justify the prosecution. It is a great shame on the criminal justice system. So, relationship in short, and maybe there's one more that I mentioned here. The letter that is before the court that my learned friend referred to, dated 22nd of January 2020. Relationship, that letter suggests that the evidence that was collected by the scenes of crime officers in the month of September 2019 was only handed over to the government's chemist in January 2020, and therefore they require 2 months to investigate from that point. If this is how the case is being conducted, it means there is no intention of ever concluding the investigations. There is no intention of accepting there will be that it was a mistake, and perhaps it is time for us as the defense to reflect on applying for a mistrial. Your Ladyship, that letter speaks for itself. I conclude by saying, in a case such as this, an adversarial, based on the adversarial system, there should be equality of arms, as it were. Whatever time the prosecution take is the time that the defense should be entitled to take. We have supplied letters to the court dated 8th November 2019 and dated 20th February 2020, all indicating that the defense were making serious requests. For example, access to the alleged scene of crime so that the forensic expert on the defense side can conduct certain tests. Asking for phone records, asking for expert reports from their side so that the defense can exercise their right to take second opinions. I can only say from where I'm standing now that if they take 10 months, the defense will take 10 months. So to dangle the July hearing dates as an incentive to us is a mirage. As of now, this case is collapsing even at this stage. As of now, I can tell the court on behalf of the first accused, we will not be ready on the July dates. Because as of now, we have had nothing from the prosecution to enable us prepare, even start preparing the defense. Ladyship, my final request is that the court guillotines the time for presenting evidence at today. I will accept the last bundle on behalf of the first accused. The second accused lawyer has already accepted this. End it here and now. Perhaps then we might be ready in July. But as of now, we are being treated to all sorts of shenanigans, all sorts of... We were told of other accused persons coming in at the last hearing, at the last mention. We see no mention of it. All this sensation, all this drama by the DCI, and when we come to court, there is nothing. I rest my case. Thank you. About the redacted statements, Your Ladyship, I am reminded that through the course of these proceedings, we have been given at least two statements that were redacted. They want to redact them more, yet they have given some that are not redacted enough. How will that help them? Your Ladyship, I think that is just an excuse to buy time. I am reminded also that the Witness Protection Program is physically housed in the office of the DPP. So the time is not something that they can rely on. They walk across the corridor and they make those arrangements, they redact their statements, place such witnesses in protective custody, and allow us to carry on with the case. All these excuses will not help us. Thank you.